tribunal can say,
Right.
is this really a worthwhile objective for an arbitration? Because that's relevant. And also, once you ask for that relief and you know what it is, it gives the other side clarity to come back and say, well, actually, you're out of time on that. And, your efforts have been in vain. So you don't want any necessary procedural point to be skipped.
Yeah. The one thing I wanted to ask at the end is, does the constitution or the constituents of the tribunal in any way determine how you draft your SOC?
So, welcome to Arb You Listening, the podcast where we dive deep into the world of arbitration. This series is dedicated to bringing nuanced and diverse perspectives on arbitration to practitioners across the globe. Whether you're a seasoned counsel or just starting your journey in arbitration, this podcast will offer you valuable insights from top experts in the field, trained in various jurisdictions and legal systems. Each episode features discussions with experienced arbitrators and practitioners sharing their knowledge and practical tips to help you navigate the complexities of arbitration. From procedural intricacies to strategic advice, we'll explore the topics that matter to you and your practice, providing actionable takeaways for every episode. The podcast is an initiative of the India Arbitration Group of the ICC India. My name is Aanchal Basur. I'm a counsel practicing dispute resolution in India and also act as the secretary of the ICC IAG. I'm joined today by Mr. Ravitej Chilumuri, who will be my co-moderator for today's episode. Mr. Chilumuri is a partner in the dispute resolution practice of Khaitan and Company's practice group in the Mumbai office. He has worked on various contentious matters and regularly advises and represents clients in civil and commercial disputes with a focus on arbitration, insolvency and bankruptcy, debt recovery, shareholders disputes, and pre-litigation strategy. Ravitej has a vast range of experience and expertise in both ad hoc and institutional arbitrations, administered under various rules across various jurisdictions. He's a member of the ICC IAG, and I'm very happy that he's co-moderator for today's session. Welcome, Ravitej.
Hi, Aanchal. Hi, Nick. Thanks for having me.
And of course, I'd like to introduce our guest speaker for today, Mr. Nicholas Peacock, or Nick, as he's fondly known by the arbitration community. Nick is an experienced English law qualified solicitor advocate. He's specializing in international arbitration. His practice combines advisory work, acting as advocate, and sitting as arbitrator. Nick's career includes significant roles at leading international firms. He served as partner at Herbert Smith Freehills for over 16 years, where I first met him, where he led the Singapore International Arbitration practice later and headed the India disputes practice as well. He very recently joined Bird & Bird as a partner and was head of the London arbitration practice. Mr. Peacock in 2024 established his own independent practice to focus on serving as arbitrator in ad hoc and institutional arbitrations involving Indian and international parties. He has acted for and against state governments in commercial disputes and has been involved in India-related matters for over 20 years. We are very happy that, Nicholas, you could take out the time and speak to us today, and welcome to Arb You Listening.
Thank you, Aanchal. Delighted to be here. Thanks to you and Ravitej for hosting.
Oh, thank you so very much. So I think we'll get straight to what we have to discuss today, which is the statement of claim. And the reason why we are discussing it is, frankly, it's not just a pleading. I feel that it's a significant portion of the advocacy that you do in arbitrations, international and both domestic, is the first pleading, which is the statement of claim. We'll dive right in. And apart from obviously setting out the case, Nicholas, why is it important that we speak about the statement of claim? I think I just want to ask you first why is it significant? Isn't it just repeating the case of the client? Why should practitioners really focus on it?
Yeah, well, we'll get into it, I'm sure, but really the statement of claim is your first chance as a party, as a claimant, to tell your story, to set out your case in detail. It's likely to be the first substantial pleading that the tribunal reads. So it's a chance for you to set the tone, to let the tribunal know what you think the case is all about, and at an early stage, what the relevant facts are and why you think you should win. Of course, we'll come on to the prior documents you may have filed to initiate the arbitration, but they are likely to be a bit more cursory. So the statement of claim is when you really get a chance to set out your stall.
Yes, exactly. And I think it's also the first chance where actually, and correct me if I'm wrong, is when the attorneys actually sit together and decide how to take this case forward, because the documents that you file earlier may have been filed in a hurry, or
Yeah.
they may not have really given much thought to it. You're looking at a notice of arbitration. What has been your experience, Nick? Of course, first I ask you as counsel, and since you don so many different hats. So first as counsel, what has been your experience in dealing with preparation for the statement of claim? We're not talking about filing it, but like at what stage do you really start to think about it?
And I think just one thing to add to that, I think, Nick, I want to hear you on that as well, is that while this is your first substantive pleading on record, I think a lot of times the mistake people tend to make is they believe that this is your dump yard where you put in everything and anything to do with the parties and probably the matter at large, while sort of sometimes losing focus on that it's a statement of claim and should relate to claim. So I think that's something that I think we should sort of, I guess, get some sense on as to how do you make it a statement of claim as opposed to a storybook of sorts.
Yeah. Well, look, that's also a good point. As counsel, you are likely to come into the case with a bit of prior correspondence from the client. Of course, you may have been brought in early, but the chances are, if a dispute has got to the stage where it's gone to arbitration, there's a history to it. The parties will have been clashing or trying to resolve it at a commercial level. So there's likely to be some back and forth on the record, on the emails, maybe some formal letters. Maybe you as counsel help draft some legal letters, but quite often you aren't. Quite often you come in for the arbitration. So you've got that correspondence on file, which is likely to have been more commercially focused, and may have been, as you say, Ravitej, a little bit scattergun maybe sometimes. Then you will have issued a notice or a request for arbitration in ICC parlance to start the arbitration process. And as Aanchal said, that is often quite a short document. You might do it in a hurry. You might be up against time limit or whatever, but you probably don't set out your expansive case in that RFA. And usually as counsel, I would use the RFA to set out what I needed to set out. And obviously you put in the background description of the case and the relief you're seeking at a high level. But then, of course, you generally get an answer to that from the respondent, and that then allows you to see where the land lies in terms of the likely battlegrounds in the dispute. And then that takes you, of course, after the terms of reference stage, and you've got a procedural timetable, to your statement of claim. And quite often as counsel, I would say in my RFA that I wanted to reserve the right to file a full statement of claim later on. I think that's a useful marker to set down for the tribunal. They want to know what it is the parties want to do in terms of procedure. So then the statement of claim is, as we've said, the first time you really get to set out your case, put all the background in there, but also, as you said, Ravitej, make sure it's not just a repeat of your complaints previously, because this is the audience for this is the tribunal. So previously, the correspondence between the parties, the audience may have been the in-house lawyer on the other side, or perhaps the promoter or the board of the other side. You're trying to get across a message to avoid the need to bring legal proceedings. Once you're in the arbitration, the reader who really matters is the tribunal. So you are focusing on putting your case forward in the best way you can, in the most persuasive, concise, impactful way you can for that audience, the tribunal.
What I really want to know, Nick, is as counsel, when you are speaking to your client and you're in a stage where there's a statement of claim that needs to be given, is it really crucial for you to have all the evidence in front of you? Do you need to know the entire case? Are there some pegs that you can delay for later? I mean, if you don't have the time or you're pressed on time, typically, as you would know, in a lot of Indian arbitrations, frankly, the statement of claim, even at that stage, we're not really fully prepared. A lot of counsel are not fully prepared to set out their entire case. So what is it? What are the preparatory steps that you think should go before we make that first submission?
My practice and my recommendation, I know it's not always possible, you want to front end load as much as you can. You want your client to give you as much as they can right at the start, because as a counsel, I prefer a world of no surprises. I want to know what my client's case is, what the evidence is right at the start. So when I have that first discussion with the client, which, as I say, is likely to start perhaps towards the end of pre-action correspondence, certainly as we're preparing the request for arbitration, I'd say to them, look, I might want to put in the case at a summary level in the request for arbitration, but I want you then to be gathering your documents for me so that when I come to write the statement of claim, I have everything I need. And bear in mind, in an ICC process, the RFA goes in, you'll have a bit of time when you're constituting the tribunal, there's a bit of time when you're coming up with the terms of reference and then agreeing the procedural timetable. And as claimant, you're going to go first in that procedural timetable and you're going to say to the tribunal, this is the amount of time I want. So you've got those weeks, it may even be, a month or more between commencing and then getting your statement of claim in. So what I say to the client at that stage is first document hold. Anything that you think might be relevant to the dispute, your emails, your documents, put a freeze on any destruction that's going on. If anybody's due to leave the company, make sure you copy their hard drive. We've got all the necessary documents and pull it together. And of course, in the modern world, you're pulling together mostly electronic documents. You're going to want to pull them into some kind of document management system where you can then extract and review and search. So that's a good time to use that period to pull the documents together, to talk to the relevant people. If you're dealing with an in-house lawyer or a commercial contact, get them to tell you who the core people are in this dispute. Who was the liaison, who was in charge of performance, who are the people who are likely to be the witnesses. Now, I don't necessarily take witness statements at that early stage, although it could be great if you do have that time. But you certainly want to know that all their documents are captured and that the core correspondence is available to you. And ideally, you have a word with the people who are really at the coalface. You get around a table and you find out what the company's position is, what the client's position is. And again, just no surprises. I want to know everything, because when I set out my case in my statement of claim, I want to know all the best bits and I want to know what might be coming down the track at me later on. So I don't take a position that is makes that more difficult for me later on.
I think
Does that make sense to you?
Yeah, absolutely. Ravitej, a little bit of your inputs on the Indian aspect of this.
So I think I have something to add, but I also have a question for Nick at the end of this.
Yes.
But you're right, but Nick, the challenges sometimes that we face is that not every client that we come across in ad hoc arbitrations in particular have sort of managed their documents the way they ought to be. There's generally not one person involved. There's several people involved. For instance, in a construction arbitration scenario, you'd have somebody on the ground, someone handling projects, someone handling the region, then there's the head office backend and finance backend. So sometimes documents are not symmetric in that sense. So it becomes a bit of a challenge to ensure that everything is that there's a document hold, everything is in a document review management system, and then you have the advantage of that while you're sitting down to make your statement of claim. So I think in those scenarios, we have to at times keep some things for later, in the sense that it's not deliberate as much as forced at times, where we put whatever we need to in our statement of claim that we develop the case basis what we eventually want, but not everything is available sometimes at the beginning. There are times that when you get back the statement of defense is when you realize that, oh, wait, there are responses to A, B, and C. We didn't realize they were important. We didn't locate them, but now they're going back to them. And then we sort of have this whole new bunch of documents that we get when the statement of defense comes to us. So I think that sort of segues me to the question that in such a scenario, what do you recommend? Do you put that in your response to the statement of defense, or do you keep that for the witness to sort of bring in through their witness statements?
Yes, this is the real world we live in. There are, the perfection is not possible. So yes, absolutely. When I say I'd like my client to give me all the documents in a nice searchable database, of course that doesn't always happen. But as a counsel, you start from those those questions. Do you have documents? Who are the core people? Can we gather these documents? Of course, that's not always possible. Sometimes you'll get a nice chronology from the client who prepares that. Sometimes you'll just get a hasty description of what's going on, and you take note as best you can. So you work with what you've got. And obviously, as you say, Ravitej, you have to sometimes roll with punches in terms of what comes back in the statement of defense and possibly a counterclaim. Of course, as lawyers and as counsel in pleading out the case, you want to be as clear as you can, as early as you can, as to what your case is, because frankly, that helps everyone. And the other thing I always say to clients is, the sooner you can tell me the good and the bad, and we can put our arms around this and put a number on it, then the sooner you can take a view on how much you want to invest in this dispute, where the settlement point is, whether there's something fatal in your claim that means that it's not going to be worth pursuing.
Okay, sure. So I think the next segment is basically where, really there's a deviation between the request for arbitration and the statement of claim, right? There may be certain aspects where you want to take a different position, or you've been really hasty in filing that request for arbitration. And I'll really open the floor to both of you. Nick, what is your view as an arbitrator when you see this? And as counsel, how would you sort of tackle with this? You've already taken a position which you sort of want to.
So, Nick, do you want to take that from an arbitrator's point of view, and then I'll come in on what we sort of see in some of our cases here?
Yeah, sure. Well, from an arbitrator's point of view, if you've got a situation where you have a request for arbitration and then the case develops and comes out differently in the statement of claim, I think there's two things to bear in mind from what the tribunal is going to be thinking. Firstly, of course, there's a consistency and potentially credibility point. Does this party know its case, and is it evolving? Of course, there may be many reasons why a case evolves over the course of proceedings. And part of what good counsel will do is explain what has changed so that it doesn't alarm the tribunal. But the other very important point, of course, is if your statement of claim moves away from what was in the request for arbitration, and importantly, what was then in the terms of reference, have you fallen outside the terms of the reference and the jurisdiction of this tribunal? And tribunal have very sensitive antennae when it comes to their jurisdictional scope. And on an ICC arbitration, you set out in the terms of reference what is within the arbitration. So if something has changed between the RFA and the statement of claim, then you need to go back and just check whether you're still within the arbitration as it's been commenced, whether the claim falls within the scope. If not, you're going to need to think about bringing in an additional claim and dealing with that under the ICC rules.
Okay. What we often see is that a client comes to you last minute saying that, look, there's a dispute, there's a claim, we need to invoke arbitration right away. And then you don't have the luxury of time sometimes. And then I think with a 10-15 day window, we sort of go through what we have, largely at that stage guided by the client's claims, who sort of tell us that, look, we want A, B, and C. And that's how we sort of, and that's how you craft your notice invoking arbitration, your RFA, etc. But often we see that once we pass that stage, and then we've had the luxury of time of reviewing the papers, reviewing the documents, etc. That's probably it's at that stage that we then realize that, look, you actually have several claims that you can make against the other party, and perhaps which were not included in your notice invoking arbitration. I think when we deal with that, I think now the position that we try and take is that as long as it is within his jurisdiction and covered by the arbitration agreement, we are sort of now more liberal at the statement of claim stage, where we tend to cover for what we've missed out.
If you could tell us the elements of, I'm sure everybody has their own style. We all as counsel do follow different ways of presenting our statement of claim. But what is it that you would recommend a good statement of claim, as we can call it, should have? And also, like Ravitej mentioned in the initial part of this podcast, what are the details that you should sort of get into, and maybe it is wise to sort of leave out as well when you're drafting, your claim statement.
Yeah. Okay. Well, I'm happy to give you the benefit of how I used to do it. As you say, there's no one way to do these things. And obviously all cases turn on their facts. So if you have a case that has got a particular set of facts, you might want to emphasize a different method of putting together your statement of claim. If it's a very legal case, you might have very little upfront in terms of factual description. But let me tell you some of the headings that I would suggest in a good statement of claim. Firstly, contents page, please. Any document that is more than 5 pages should have a contents page. And if you write a good contents page and your headings are clear, and perhaps, introduce the argument you're about to make, the contents page itself is where you start your advocacy. And as the tribunal reads down that contents page, they see where they're going with the case, they see what your arguments are, and they're already understanding the case you're going to put to them. So contents page, yes. Introductory paragraphs. Why are you filing the statement of claim? Is it in compliance with a rule or a procedural order? Give the tribunal a nice and clear statement that you know what you're doing and you're complying with the procedure they've set out. I would also, right at the start, have a paragraph, 2 at most, where I set out my case theory, where I tell the tribunal, as you do as an advocate orally, this is what this case is all about in 1 or 2 sentences. We performed everything we had to and they just failed to pay. The goods turned up, but they are just defective, or there's just not enough of them. Whatever the case is about, give it in 1 or 2 sentences right at the start, so the tribunal is orientated before it reads anything else. Then what I'd probably do is I'd say this statement of claim will now proceed in the following headings, just to emphasize what I've done in the contents page. Tell them I'm going to run through the parties and the background and the contract, and then get to the claims. So again, lots of road mapping, as it were. Then you're going to set out the parties. Just helps. Bear in mind you're drafting a document that you hope the tribunal is going to use in preparing its award. So all the headings you want in that award, useful to give the material in the pleadings. I think you're likely to set out the background to the contract. Obviously, all arbitrations have a contract. That contract has a history to it. What can you say that's relevant to the dispute? Don't bother giving lots of irrelevant details about how everyone's known each other for 20 years. But if it's been a good relationship until a certain point, and that's part of your case theory, then you're going to say that. So a bit of background to the contract, and then, of course, the contract. You're going to focus on it. Of course, you're going to be setting out the arbitration agreement. You will have done that in the request for arbitration as well. But make sure you get on the page those relevant terms of the contract you want the tribunal to focus on. Most cases will turn on a handful of clauses in a contract. So get the tribunal reading those clauses that you say have been breached, and then those clauses of the contract that you say assist, support, don't prevent or cut down the claim you're bringing. Then, of course, you're going to get to the breaches. This is the meat of the submission. How has the dispute arisen? What has been done that is a breach? What have you done to perform in your best endeavours? Obviously, that's the meat of it. And as I say, depending on the sort of case you have in front of you, you may adopt that in a variety of ways. Do not forget about loss and causation, and do not forget about quantification. You mentioned that, Aanchal. We might come back to it, but unless you're going to ask the tribunal to bifurcate the dispute, that is to decide liability and jurisdiction first and then quantum second, then tribunals would like you to deal with quantum nice and early. And if you are bifurcating, you'll have dealt with that at terms of reference, because that will be reflected in the procedural timetable attached to terms of reference. So you'll know whether you're bifurcating. So if you're not, again, now is the time to say something on quantum. If it is a case where quantum is going to have to be decided by an expert, then that might be a unique situation where you deal with that later. Hopefully that will have come out in establishing the procedural timetable, and it may be that in those circumstances the tribunal has ordered memorial submissions where expert reports go in with a statement of claim.
Right.
But otherwise, yeah, like you to deal with quantum, please, as a tribunal, and the ICC will be asking you about the quantum of your case anyway, because of course that's the way the ICC establishes itself. So there's no getting away from that quantum issue in ICC arbitration. And again, say to your client, we need to grip this now. we need to know what this claim is worth, because otherwise, how can you at a commercial level know whether this is worth fighting and what the settlement point is? And even if you think it's never going to settle, how important is it to you as a business? It may be an emotionally important one, but what's the actual value to you? And therefore, what do you invest in it in terms of the arbitration process? Don't forget the relief sought. Set out a nice, clear explanation of the relief, possibly even the orders you're asking the tribunal to make, ideally. Again, clarity for the tribunal. Do the best you can as early as you can. They may get tweaked over time, but the sooner you can tell the tribunal that whether you want damages, whether you want specific performance, what order it is you want, what declarations you want, the better. So that's all assuming you got a claim. Of course, later on you might deal with a counterclaim, depending on how the pleading has been set out and depending on whether that counterclaim has been raised in the answer. You might not. You might try and deal with it a little bit in statement of claim, but probably you'll leave it until it's been actually pleaded out.
I think that's a great point. Firstly, thanks, Nick. This list, I think, is absolutely fantastic. I've made my notes, and I think we're going to just sort of flag it out of the episode. I think it's fantastic. Thank you so much for it. But having said that, I'm just going to bring you back to 2 points. One is the relief. And I say that because, technically, when we are doing a domestic arbitration, and maybe Ravitej, you can sort of put your inputs here. The reliefs tend to be slightly technical, of course, depending upon the tribunal that you're facing. Some tribunals look at it in a very, very technical manner. So, in the event your relief is too vague, or what you've asked for is, say, for example, simply a declaration without there being any consequence to that declaration, they are unlikely to sort of take it one step forward at the stage of granting an award. My question to you is, I mean, what has been your experience sometimes? And that really was the question on the RFA as well. So, for example, experience sometimes the relief in the RFA, because some parties like to put their relief in the RFA as well in much detail, is very different from what they do end up claiming in the statement of claim, just in terms of quantum as well. So, for instance, we was part of this arbitration where they, sought for damages on contract plus the loss of profit in the RFA. But in the statement of claim, it was an alternate relief instead of an additional relief. So what has your experience been in terms of just drafting the relief clause? Because I can tell you in India, when we look at a suit or a case that is filed, that's one of the first, sections that a judge would look at. Like, okay, what is your prayer? Let's just go backwards from it. Yeah. Any tips on handling that? We go backwards from it when we're looking at arbitrations? What's your?
Yeah, again, you've got to grapple with it, haven't you? And if you're running an ICC arbitration, then Article 3 says that your request for arbitration must contain a statement of the relief sought together with the amount of any quantified claims. So you'll have had a go at this already. And again, I think from a tribunal's perspective, the sooner you can be clear to me what it is you're seeking, then the sooner I can get a handle on the sort of process we need. I mean, it's going to be relevant to the procedural timetable. If you're asking for hundreds of millions of dollars in damages, then that might be relevant to the sort of time that's allowed for the procedure. If it's a relatively modest claim, or if it's an urgent declaration to be made about something that's coming up, then obviously they will feed into the timetable that you set. And of course, don't forget in the ICC procedure, you've also got expedited process, which kicks in at certain values. Right. So again, you're going to want to be clear about what the value of the claim is nice and early. Again, tribunals do understand that cases can evolve over time, and especially if new documents come out during the arbitration, new evidence comes to light, or an expert comes into the process and they have a particular view on quantum, for example, or on loss and causation. So tribunals appreciate that. But again, as a counsel, you want to try and be consistent throughout the process if you can, to do your thinking up front, to make sure the relief you are seeking is sensible. As you say, Aanchal, if all you're asking for is a declaration with no apparent consequences to it, it's best to understand that early so the tribunal can say, right, is this really a worthwhile objective for an arbitration? Because that's relevant. And also, once you ask for that relief and you know what it is, it gives the other side clarity to come back and say, well, actually, you're out of time on that. Actually, that's that's cut off by the contractual provisions. And of course, again, hopefully that's not a surprise to you. You've seen that coming and you've got your answer to it. But if you haven't seen it coming, you certainly need to get that out nice and early, because as counsel bringing the claim, you don't want to be surprised by really important defences after you plead out your case and after you've eventually put a handle on what your relief is. So yeah, as soon as you can, I think.
I think it's just two big things. One is, I think there's this school of thought when we were younger, which said that draft your reliefs first and then draft the rest of your statement of claim. Because once you know what you want is when you'll know how to get to asking how to sort of get that relief. I don't do that, but I still know some who do that. But that's an interesting way to sort of look at it as well. And the one thing I just want to sort of come back to when you point out, which is very interesting, is you said, when you start with the relevant background. I think what's important to note there is we often mistake background facts for historical facts. Because what happens with historical facts is you end up putting everything under the sun what's not relevant, as opposed to the bit of the background that's just relevant to the case you're trying to make. I think that's important for us to sort of take away from this, is that when we say relevant background, what we mean is relevant background, as opposed to just putting in everything.
Asking today is a lot of the arbitrations, especially the ones that are time pressed. It is of course advisable that you get experts right there up front, but it may not always be possible for as counsel to get to do that, or the experts to also complete their evidence. What happens in a case where you are unable to quantify, but you really, and you're not in a position to exactly set out what your case at that point is? You do know what bucket it falls under in terms of the quantum of it. And would it be possible for you to then expand it in your evidenced affidavit? So for what I'm really asking is, at this stage, you're not certain, your client comes to you, he asks you, okay, listen, this is the loss that I've suffered, on this aspect or this particular point. I cannot quantify it at this moment, but I want you to plead it. And of course, we have to plead it because it's the statement of claim. What is your advice for counsel at this stage? Can it be built on at a later stage? Of course, it's not advisable, but then what would you do?
Yeah, you've got to ask yourself why you can't come up with your quantification now. There will be cases where the relevant documents are in the possession of the other side. Right. There are also cases where it's a piece of work that the client doesn't want to grapple with now. And I think it's important that you ask yourself why, because you're probably going to want to explain to the tribunal why. Because if you're not going to quantify your claim now, you probably need to have an explanation for that. It's because the relevant materials are in the other side and we need to get them out on the document request stage. It's because this will need to be quantified by an expert, which in accordance with the procedure we put at a certain point. And as I'd say, going back to something I said earlier, understanding that part of your case for you and for the tribunal should have an influence on what procedure you come up with. And I've had cases, especially as respondent, where I've thought the nub of the case is the quantum of damages. Maybe we've got a case that really turns on the other side demanding an amount that my client thinks is excessive, even though perhaps they think they've not got much of a position on liability, but it's all about whether the claimant realizes their claim is for hundreds of thousands or tens of thousands rather than the hundreds or tens of millions they're claiming. At that point, if I'm the respondent and if I'm trying to persuade the tribunal, I say it's important that we get out early the value of this claim. And so I actually ask for a procedure where we have memorial filing. So the claimant, when they put in their statement of claim, puts in witness evidence, expert evidence, and a full quantification if that's coming from the expert or wherever it's coming from. So again, it's about understanding why you can't quantify your claim and what you need to do in order to quantify it. Again, if you're the claimant and you're in that position, unless there's a reason why you want to surprise the tribunal with a number later on, I'd be saying, well, can we have an order that the experts shall be instructed at this stage, assuming I have the material to put before my expert? Because I want the tribunal to see nice and early the value of the claim, and I want to put the respondent on the spot. If I hold the contrary view, they say it's not worth tens of millions, and I say it is. I want to know very early on why they say it isn't and what their expert's view is. So in that case, I might want a memorial style submission to get that out in the second round of pleadings in that defense memorial, rather than waiting through all the pleadings, all the witness statements, all the document production, and then only getting the expert reports later on.
It really just
Yeah.
opens up your case to being attacked on grounds that you wouldn't want it being attacked on, and really shows your unpreparedness, I would say, as a party.
That's
in terms
actually a
of
very interesting way to put
Okay.
it. Yeah.
Yeah, and it goes to efficiency. Remember, tribunals will or should be really focused on what the most efficient way to deal with this case is, including, although it might not be an explicit part of the mandate, how do the parties crystallize their claims early enough that settlement, if it's going to happen, happens.
Yeah.
So tribunals will be wanting to think about in this case before me, what is the best procedure to follow? What goes into that statement of claim? Is it just a legal pleading? Is it pleading and documents? Is it all the evidence as well? And is there important expert evidence that we need to get out early in order to do things like quantification?
Fantastic. So I'm just going to also get now to the last part of this podcast. I know it's been really action-packed, but we do seem to head for the end timer here. Ravitej, I'll start with you. Any questions for Nick in terms of the practical tips? I mean, something that you can quip in from an Indian perspective. And I think then we can open the floor to Nick for our young practitioners. What are your tips in terms of just strategies and preparation on this vital document?
So just quick, two things actually. One is, what's your take on amendments to statement of claim? The reason I ask is that's something that's become fairly, in a couple of my recent cases, it's been quite contentious. That
I'm glad you did ask this. Yes.
Yeah, because one is, do you permit amendment? To what extent do you permit amendment? And then can your claims be rejected despite the amendment being allowed, saying that, look, I allowed you your right to amend, but I don't believe this was part of your original case, so therefore the claim goes out of the window. So how do you look at amendments to statement of claims generally? And I ask you this question largely from an arbitrator's point of view. I have another strange question for you after you answer this one.
Okay,
yes.
Deal with that one first then. As an arbitrator, my first reference points will be the procedural law and the rules. And of course, in an ICC arbitration, I go back to the terms of reference and I look at the Article 23, isn't it, that deals with that. So, if a party wants to amend, the first thing I will say to it is, well, are you requesting to make an amendment? In that case, please, explain to me the basis on which you're making the amendment, the rules on which you say I can allow it. Now, some institutional rules will say parties can amend the case unless the tribunal decides otherwise, in which case the decision you have to make as a tribunal is whether to positively stop the amendment because of the circumstances when it's brought or whatever. Other rules will say apply to amend. Some procedural laws may say apply to amend, and some jurisdictions will have a bit more formality around that amendment process. Again, I think as a tribunal, you want to not overcomplicate things, but of course you want to take things in a sensible order and make sure that at all points your decision when it comes, whoever wins, is not challengeable on the basis that you fail to follow mandatory rules of procedure. And of course, as you say, Ravitej, always keeping an eye on jurisdiction, whether the amendment you're making is going to fall outside the scope of the reference to arbitration, whether you're under ad hoc arbitration or you're under ICC rules or any other rules. That, of course, is critical. It should be for the tribunal. But you as a party, as a claimant, don't want the tribunal to miss that point. Because if they nod off and fail to spot that what you're doing is bringing something outside the arbitration clause, the reference to arbitration, it just gets challenged later on. And, your efforts have been in vain.
Yeah.
So you don't want any necessary procedural point to be skipped.
Yeah. The one thing I wanted to ask at the end is, does the constitution or the constituents of the tribunal in any way determine how you draft your SOC?
Absolutely. Absolutely, it does. And I think it's so important, and you'll know this as within your own practice, depending on the tribunals you get. For domestic arbitration, for international arbitration, it absolutely makes a difference. You address your audience, just as you will in court. If you've got a certain judge, you know that he or she favors an approach, doesn't like some arguments, has a hobby horse they like to ride. The same for arbitration, of course. Whether you've got a sole arbitrator or a tribunal, you need to address the personalities involved, and especially in international arbitration, the legal traditions involved. If you have lawyers from a certain tradition, ask yourself what difference that makes to how you present your case. It may be as simple as saying, well, I've got 2 out of 3 of the arbitrators here don't have English as a first language, so I need to keep everything really straightforward and simple in terms of my phrasing. If they're not Indian lawyers or English or Australian lawyers, there's not a lot of point putting a lot of cricket analogies into your statement of claim. Always be careful about, local idioms and ways of speaking that won't translate. But yeah, absolutely. I think good counsel always ask themselves who they're addressing and what difference that makes. Again, the answer will vary depending on each situation, but the audience is ever important.
Great. That's interesting.
Great. I think I loved the last question. It was a fantastic one. Nick, any parting words for us? Any tips for us, for our listeners here? And again, thanks so much for taking out the time. I really, really appreciate it. But please, and I love the contents. I mean, I've noted it down. We're going to put it at the heading of this podcast. And thank you for setting out that list as well. But any parting tips for us, please?
Yeah, well, I think we picked up most of what I was going to say in terms of takeaways. Absolutely. I think the last one is really important. Think about your audience. Think about their viewpoint. Think about what is going to trouble them in giving you the relief you are seeking. I had a case years ago as counsel in Indonesia when I was based in Singapore. And we had a case in Indonesia where my client was pursuing sums for a construction project where they'd done the work and the amount was due under a mechanism under the contract, but it was more than the headline number at the back of the contract. And the other side, the respondent, we thought was just worried about paying because of allegations that it was paying above the contract price, that there'd been bribery or corruption in there, which is, a real issue in many jurisdictions. And we also thought, well, the tribunal will want to grapple with that as well, because as it happened, the respondent was a state party, state-related entity. And the tribunal's also going to want to know that it is not being used as a vehicle for doing anything untoward, and that if a decision of the tribunal is challenged, they're not going to be criticised. And so we had to grapple with that. We thought about that bit. That was going to be a major concern of the tribunal. We had to address it up front. We had to explain why everything was legitimate, why we'd done the work and evidence all that, and why there shouldn't be a concern around, frankly, the other side paying or the tribunal ordering them to pay. So I think, that's about thinking about your audience, and it's about thinking from their perspective, what are the hurdles they will need to get over, and how do I help them get over them? And how do I give them the materials they want to put in their award at the end of the day to give me what my client wants? So I think that's the number one takeaway. The other one is just read your rules. Read your rules and read your procedural law. Make sure they are your constant companion so that at every point, if you want to take a procedural step, you're not going outside what the rules say, and you can tell the tribunal, I am asking you to do this in accordance with this rule, in accordance with this section of the Arbitration Conciliation Act, or whatever procedural law is governing.
Fantastic. Thank you so very much. Thank you, Ravitej. Thank you, Nick, for your time and for your patience in recording this episode. I believe this has been one of our most challenging recordings till date, and I'm so happy that you managed to sit through it with us. And thanks so very much. It was an absolute pleasure. And I look forward to meeting you in person again and also doing more things with the ICC IAG. And now that I know you have a copy of our BEAR Act, we're going to pull you up even more for India-related stuff. Thank you. Thank you so very much.
Yes, well, it's been my pleasure. Thank you for your questions, your contributions, and for bearing with the technology. Resilience is an important part of any arbitrator's toolkit.
Perfect. Thanks so much. Thanks, Ravitej. We're
Thanks,
going to
thanks,
end it
Aanchal.
now
Thanks,
and
Nick. Thanks, everyone.
coordinator. Okay, thanks so much. Thank you. Bye
Bye.
bye.